that's just to determine whether or not the basis of the complaint appears to be, and it doesn't have, you don't go through the process of proving the whole complaint. It's just you want to make sure that the complaint has some degree of merit. Even if the officer isn't named, I don't know who it is, but we certainly did have an incident occur at this location, police were involved, we'll handle it as a complaint. But if they specifically name an officer, for example, who either isn't on the job or is out of town, it can be demonstrated that officer wasn't even here, we've had complaints like that come up, you wouldn't follow through with that. You may have to change it. You wouldn't necessarily make it against that officer, but the investigation rule that. Or, for example, a very common one. The police came and they took property from him. They stole it from him. And then when the intake officer takes a look at it, they look at the complaint, they pull up the report, and they see the property is listed on the report, it's placed in property and evidence for the receipt. Well, clearly it wasn't stolen. There is no complaint of that nature anyway. So clearly it's not stolen. You wouldn't open up an investigation on that because it's clearly that it's been resolved right then and there. That's what I'm talking about in terms of doing due diligence.
Another issue is sometimes there's other law enforcement agencies that do police work in the city. And NOPD officers get accused of taking some police action and it wasn't an NOPD officer. And that will take a little bit of a time to determine that it wasn't NOPD. It was the sheriff department, probation and parole.
Especially with plainclothes officers. It could be state police, it could be sheriff's office, it could be federal agencies, it could be, who knows, probation and parole, it could be anybody. So there's a certain amount of due diligence that goes into verifying the complaint and making sure that the right person gets the right complaint, or not at all.
I want to just flag that the time limit issue is like currently under litigation and that the Supreme Court recently ruled that PIB is not doing it right. So I need to confirm, this is probably their process, but I need to confirm that it's actually legal.
But specifically where Ursula was referring to is when PIB opens up a criminal investigation, this is what Captain Glasser had mentioned before. And what PIB has been doing is they've been tabling the administrative violation because they let the criminal investigation, they go through the criminal investigation first, and so they stop that time period until their criminal investigation is finished with, and then they start the administrative time period. And the court specifically said that they were doing that process wrong as compared to this process of the 14 days preliminarily and 60 days with one extension.
So I think we need to do some legal research. I'm going to table step 1.
But do you feel like as a chair that we can make a decision about whether we as a planning committee like the idea of having an alternative process that we call mediation instead of complaint intake, which would be outside of the 60-day time period?
Okay, we can.
I'm asking you as the chair if you think that's a good thing to bring up now.
Okay, assuming that it's legal. Which is a big assumption. How would y'all feel about deeming mediation and a different process than complaint intake?
I would have strong feelings against that just because I think that people should have the option, if the mediation is unsuccessful, to return to the PIB. And it sounds like if you were to intake it as a separate kind of case, then it might, I mean, would that preclude then being able to?
We want both parties to feel okay and participate, but from the officer's side, it seems like the incentive, going back to what we talked about earlier, what is satisfaction going to be? And it's going to be varied from different individuals. If I'm going to go through the process, potentially for a person to not be happy, and then to just go back and make a complaint and it starts all over. One, you got the 60-day issue if it goes through beyond that period, because we're talking about setting up something that's outside of that. Then it's going to come back. The 60-day issue is a moot point potentially at that point. But why would we set up something to try to incentivize both parties to participate? They agree that they're going to participate, and then because somebody is not happy with the final outcome, they decide to go back to where the beginning, where the choice was made that it was going to be a mediated complaint or a non-mediated complaint. That doesn't seem to
You just
follow.
can't have two bites at the same time.
Now, they will reserve the right if they choose to go outside to the court or something. They always have that right, even through a PIB complaint, so that's a separate issue. But to come back to point A again and go off a different track, that doesn't seem to be a good process.
If we just described a quick court model, just so we have the back of our heads, that the quick work this point, you know, if there's a complaint, it's large, you know, opposing parties. It's when it gets in front of the judge that says, hey, you guys want to resolve this mediation? Either party has the right to say no. They both agree, it goes to mediation, mediate, come to agreement, great, resolve, walk away as friends, whatever. If it's during mediation, if it's not resolved, then it kicks right back in front of the judge, it'll go right back in front of the judge. So I'm following both mind frames, what you're saying. It sounds as if you want to keep the option open so it can kick back, so the person still has that kickback. And he's saying the initial separation in the beginning, the incentive, you walk away whether or not it's agreed upon or there's a disagreement. So I think if we follow that, the courthouse model starts off as a complaint, quote unquote, and they have the option to either branch off and say, okay, you have the option to mediate or let the investigations commence. And if they so choose to mediate and it works well, hey, you walk away as friends. But if there's a decline, if there's a disagreement, then both parties, considering both parties, could be just left in limbo. Okay, what do we do with this issue? I think it's how do you open the door that okay, we can be right back to square one like in the courtroom model, because there's obviously a complaint that wasn't successful.
Well, here,
Yeah.
but my thought process was the issue of mediation wasn't so much as to solve the encounter, or to necessarily come to some type of total agreement on who maybe was at fault, or we didn't have enough information on what each party did, but was to discuss and express satisfaction, dissatisfaction, and the possibility of better understanding, a better relationship was the result out of that. If that doesn't happen, that doesn't mean the person should have a right to go back and remake another complaint. If I'm an officer being accused of, let's say, discourteous, let's use something like that, something I supposedly said or whatever the case is, and I'm going to come and face this person, because that's basically the way I'm probably going to feel, whether I did something wrong or not. I face this person, the person's going to accuse me of saying X, Y, Z. I didn't feel I said that, or I didn't say it that way, or whatever the case would be. So in the end, I said, I understand the way you feel. That's not what I said. If you take it that way, or if you believe I said that, I apologize. The person's not happy. Now they get a chance to go back and make another complaint. Why would I go through that if that's a possibility?
I think that's the other complaint. I think it's still the same complaint. The question is, so what do we do if it's not resolved? Does that complaint dissipate, disappear
I
totally?
think that comes
Here's
under
the
the
question.
heading of what we discussed in the very beginning. What is resolved? I mean,
Yeah.
What's
the idea is that you have an opportunity to say what you want to say to the person involved. That's the success, is being able to do that. There is no action that comes with it.
Mr. Chairman, and here's one last thing. On the issue of resolve, if that's how we would define it, what percentage of those that have been out there technically are considered resolved? See, that's the other issue. It's a very small percentage. So we would potentially be talking about a lot of cases going back to the time. So then what is the real purpose of us doing the mediation and getting the officer to participate?
Well, I guess if there's a breakdown, like for example, like, we're just not going to see eye to eye, screw you, I'm walking out. There's a breakdown, so there's still, but you know, if we get to that point where, okay, I got the air out, let me shake hands, then obviously it's gone. I guess we haven't gotten there yet, so what happens when there's a breakdown?
Right, we have yet to define unsuccessful mediation. But what I wanted to do was flag that I see the connection between these two issues, but what we started off talking about was the intake process. And so I just wanna see if we feel like we can make a decision about that intake process without knowing what happens if somebody wants to come back. I would also just like to share that my personal opinion about this is that mediation is only unsuccessful if somebody walks out. And that's the only time that I wanted the complainant to have the ability to go back and lodge a complaint. If somebody just refuses to complete the mediation. Well, specifically, if the officer refuses to complete the mediation.
But getting back to the initial question, what the initial question was, do we feel as a body we can make a decision now about mediation being a separate process than complaint intake for the purpose of the 60-day rule in the Bill of Rights?
One thing I just want to make sure we're clear on. If the complaint is coming in to PIB, you cannot separate that by calling it a different process. The clock is going to start ticking in some fashion. The complaint goes to XYZ, the department is not aware of it, there is no clock ticking at that point. Once the police department becomes aware, member of the police department, and officer of the police department is aware of a complaint, the clock starts ticking.
Well, so, and that's my question back to you is, why do you feel that that's the case? Because legally, just hear me out, legally, what could happen, and what we did when we looked through the Bill of Rights, tried to get a legal opinion on it, is that it could, this complaint, and it's a little bit of a legal fiction, frankly, that we're talking about, this complaint could no longer be called a complaint. It could be called, a mediation subject, and then it wouldn't be subject to the Bill of Rights, if that's something that we propose.
Well, I think that's okay potentially, but it can't go into PIB because a mediated complaint and the clock doesn't start ticking. That's what I'm saying.
But
And I think the law is pretty clear on that. I think the law basically says once the department becomes aware of a complaint, the clock starts ticking. So we can call it whatever, but the 60 day is ticking. If it goes into PIB. Now let's say the mediation center is located in some other office. The complaint goes to that office. Clock hasn't started ticking yet. The police department is not aware of that complaint. No official of the police department has been made aware of that complaint. So nothing's going on for the 60-day rule on that complaint. The moment a police person, official, becomes aware of that complaint, the clock starts ticking.
But the issue there is that then any individual who goes to the PIB office, who never heard of mediation,
Right.
immediately either doesn't have the mediation option or has to take the option with the clock ticking. See what I'm saying? So even if the PIB office says, you could go to mediation, so that person goes off to the mediation office, but that clock's already ticking. Is that what you're saying?
Yes, if they tell them what the complaint is. Now, if they just go and say, look, I want to make a complaint on the officer, on an officer, let's use this as an example. And let's say PIB says, okay, before we talk, here's the areas where your complaint could be mediated. Now, they haven't focused on an officer, they're talking about a general complaint.
Then we're not ticking yet.
They're not ticking yet.
Okay.
The person looks at this form, a document, a pamphlet, or whatever, and say, well, you know what? My complaint is this complaint right here. Now, the PIB intake person could say, okay, then, would you want to mediate your complaint? Yes. They go over to the mediation center. Now, let's say the mediation center finds out it's a little bit more than what the person initially thought. And they refer the complaint. They maybe type it up, maybe refer it back to PIB. Then that would be appropriate. But if PIB gets into the details on any fashion of what's going on,
Well,
clock
that's
starts
the
ticking.
question. Will PIB be willing to triage before they actually hear the
And
complaint?
it's also a slippery slope, because
Yes,
what
it
you had
is.
said before is, and I personally legally have a difference of opinion with you, but what you had said before is if an NOPD employee actually is aware of the complaint, then the clock starts to run for the Bill of Rights. And the only reason why I'm raising this issue is because our council had said, technically you could say if an NOPD employee knows of this complaint, it's not a complaint, they've called it a mediation. And really, the problem with this conversation is that we're, the only person that really has the answer to this question are the courts above.
Right.
Right, because, I mean, PIB can say one thing, civil service can say another thing, our council can say another thing, but unless it's litigated, we don't really have a decisive
Right.
opinion
So
on it.
there's a third aspect of intake that we're kind of ignoring, and unfortunately is a fairly serious one, and that is that besides people going to an outside agency like your office, for example, or anyone else, or DA's office, or any place else they go, and going to PIB, the third one is when they approach the supervisor. If someone comes up to Simon or I and says, I want to make a complaint against an officer, I have an obligation to take that complaint, write it up, and get a DI-1 and the control number cut. And when PIB gets it, it's a complaint. It's already there, okay? So there's no option at that point. I would have to then turn around and be the intake and say, well, do you want to go to mediation? And I have to send it to mediation. So,
You make the decision on whether it's a DI-1 as a supervisor?
oh no, I have to cut it. I don't make that decision. I have to take the complaint. I can't not take it. I can't tell them, I'm sorry, I'm not taking your complaint, it's not valid. I can't tell them, no, I'm not taking it all, go see PIB, okay? We as supervisors, all supervisors in the police department have an obligation to take that complaint and write it up.
And
You
so
don't
does the
mess up.
clock start ticking when you,
Yes, it does.
you write it up?
Yes, it does. Yes, it does. It starts ticking.
Now, that takes into, if a complaint goes to a supervisor, and the supervisor sends it to PIB, which that's basically what would happen unless there's some other process created, then PIB will make a decision because the clock has started ticking. That one will be on the fast track because they are now aware of that complaint, that they have to make a decision whether it's going to be investigated or whether it's going to be mediated and ship it off one way or the other.
The vast majority of our complaints are actually rank initiated.
Yeah.
Okay, and they come from supervisors to subordinates who know an infraction, they're usually statutory issues, they follow a rule of some
But
sort.
it's usually not initiated by a civilian complainant in the first place.
No, not usually, but if it does, many of them sometimes are. If a civilian comes up and complains about an officer, we don't have an option.
You come to the stage and
Right.
complain
It's just
about
that simple.
an officer doing whatever.
Right, there's no option, we have to write it. So that whole mechanism would have to change in order for this to function. We would have to start referring people to PIB as opposed to taking complaints in the field.
Or figure out some other way, like whether it's like litigating or whatever. I mean, I think about this in the same way I think about the diversion program. Like they bring a charge up against someone, and if they agree to the diversion program, then they don't process the charge unless later they don't follow the diversion program and they
The
reinstitute it.
problem, the difference is with the diversion program, there's no time limits. They're not under any gun to do it within a certain time frame. This you are.
But-
That's the difference.
I mean, I guess I'm just the kind of person that refuses to believe that there's not a way to create a structure that would stop that clock if it goes into mediation.
She's
Well, there
talking
is,
about
but you have
creating a
to change it
diversion
through the law.
program as mediation. So what she was referring to, and I don't pretend to speak for you, but I think that what she was saying was that it's the same thing in the court process. There is a time clock that runs in a normal court process, and then that time clock stops when the diversion is agreed to in the same way that a mediation would be agreed to under the time structure of PIB and the complaint
Right,
process.
the difference is you can always drop the complaint, criminal complaint, and you can always resurrect it later. You can't do that with an administrative complaint.
Yeah,
You
that's-
can't stop
that's
it,
why I'm
then
a little
restart it.
uncomfortable with these
You can
comparisons.
with
This
a
is
criminal
labor
complaint, you
rights
can't.
issue.
It's
Right,
not,
this
it's
is
apples and
not
oranges,
an
it's not the
issue
same
of
thing.
criminal law, and it's not an issue of civil litigation. Right, this is about labor protection, right, and that's why those laws were written. And I just think we need to do some more legal research, we can't really answer this question.
Certainly, it would be good, and I believe we can come up with something, but the question is, what are you calling it? And once a police official is aware, the clock is ticking. I know you said and the only answer would be the courts above, but until then, I don't think you want to do something that might test that.
Right.
That's, I mean, if something happens to cause us to test it, but I don't think we want to build a system knowing that it's got to be tested to find out. I just think we either come up with somewhere else where there's going to be intake, so the clock doesn't start ticking, or if it is gonna be PIB in your office, you realize they're coming in under two things. One's coming in with no time frame yet, the clock is not ticking, and the one that's going into PIB, the clock is ticking. I mean, you're gonna create a double intake with different constraints.
And at this point, I think, what's our percentage? We've taken 15 or,
Less than 10%.
yeah, 10%. So, you know, we can't have these two standards anyway.
Yeah, I mean, we have questions for PIB, but I'm wondering if we had, like, for the AGs and PIBs.
Yeah.
Yeah,
Well, I'm gonna bring up this, I think that probably, unless anybody feels differently, I'm gonna bring this issue up to the board about whether they feel that they have enough information to actually make that decision. And if they don't, whether we should be approaching the AG's office or the city attorney's office and getting an opinion from them.
Sorry, make what decision?
Making the decision on whether there can be an alternative route for complaints in which that 60-day time period is not applicable. Whether legally we can do that. Our counsel with the Inspector General's office felt that we could, and that we could name that different route mediation as compared to complaint intake. It would be two different forms, but she also didn't realize that complaints are also initiated by approaching supervisors in the department. That the time clock starts then.
What percentage would you guess comes from direct contact with supervisors?
From citizens with direct contact with supervisors? Yeah, I'd be hard pressed to put a percentage on it, but it's significant.
Is that the question? I'm trying to understand. Are you trying to find out how many complaints
How many
are
complaints?
caused by citizens going to supervisors
Right,
and
right.
complaining?